Hello, everybody.
Garrett Russell Hickerson, Jr., 214-713-409.
Morning, Your Honor. Michael Crawford, that's who's approaching. Sir, state your name, please.
Garrett Hickerson.
So there were 2 counts of attempt R&O that he pled to, and I sentenced him to 465 or a year on one case, 4 days court work. I sentenced him to 325 or 1 year on the other case, count 2, I should say. Those sentencings took place on August 27th. I now have a charge that alleges that he failed to attend the court work program on November 23 of 24. How does he wish to proceed?
Your Honor, my client would plead guilty to failure to attend the court work program.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead guilty here, I'll even though you're not on probation, I'll still follow that rule. So you could get 10 days since you have one prior technical violation. Do you understand that? If you plead guilty.
Yes, sir.
All right. Did you sign, read, and understand an advice of rights form here today?
No, I didn't.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
You understand that, sir?
Yes, sir.
All right, take your time. Make sure you read that. You understand those rights, sir?
Yes, Your Honor.
And that is your signature?
Yes, sir.
And you understand you plead guilty, you're giving up all those rights, and there will not be a hearing or a trial.
Yes, Your Honor.
All right, to the charge that you failed to attend the court work program on November 23 of 24, how do you plead?
Guilty.
Did you fail to attend on that date?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
Anybody promised you anything to induce you to plead guilty?
Nope.
All right, I'm gonna accept that plea. And that will apply to both counts. I'll accept the plea to failure to attend the court work program on November 23 of 24. Okay, John, I'm gonna need that read our way. Why wasn't he there? And how many times has he missed?
Your Honor, he missed initially. That was his.
I'm sorry.
He missed initially. There was an original violation.
Right.
That was, again, there was a misunderstanding at the very beginning that he had to do court work program already. That was presented to the court. The court took action. He understood fully. He complied fully in his mind, Your Honor. He went to all of the court dates as he was instructed to. But Your Honor, what happened was at that last hearing, you sentenced him to an additional court work day. And it wasn't identified here on the record. He went and talked with probation to find out which day. The day wasn't identified on a particular day on the calendar, so he didn't know when he left his courtroom. He went to talk to probation. It wasn't identified then. He was informed that it would be mailed to him when he would be serving that additional court work program. Your Honor, his notice got lost in the mail. So seriously, Your Honor, take a look at this here. We showed this to the court. This was mailed out apparently on the 13th of November. The date he supposedly missed was November the 23rd. And apparently the post office lost track of it. The address you guys—
Let me slow you down a second. Ms. Wiles, your name?
Elizabeth Osprey, Your Honor.
I sentenced him on that case. It looks like back on October 1 of 24, the failure to attend the court work program. Did I not?
Yes.
Yeah.
Well, we didn't just mail out a notice on November the 8th or 6th for
The 13th, Your Honor.
13th for a November 23 date, did we?
No, Your Honor. He met with me in my office on October 1. He signed and received his notice for his days. He was a no call, no show October 19. He did not report to probation within 5 days of the miss. When we allowed him to continue on the court work program, I mailed out the notice to him in an effort to get him completed with his court work program. He did not show for that rescheduled date. That was only one date, and it was to hopefully make up for his October 19, in which he failed to even communicate with the probation department on.
But that's what she communicated.
Slow down. Let's talk about that letter.
Sure.
What's the date on that letter?
The date on the letter when it's dropped in the mail by the court is November the 13th.
What is the date? What does the letter say?
Notice to appear,
For what?
court work,
Is that right?
yeah. And it says November the 16th, which he attended because he was aware of November the 16th, but it doesn't identify November the 23rd.
Do you have a,
Up at the top, highlighted in blue, it indicates failed to show for court work program on October 19th. Therefore, November 23 is added. Your remaining days are November 16 and November 23rd.
No, the point is, I'm not blaming the probation department. I'm legitimately going to show the court that apparently the post office had some problem delivering this. It says unable to forward. The address itself does not include his trailer. He lives at a trailer park. This would have been sent to the office. So the post office had some issue with it, and they didn't get it in order till around about 12/3 of 24. So this was after he had already missed it.
did you not just tell me that he signed a notice indicating he would be there, or at least one of his scheduled days was on this date of November the 23rd?
No, Your Honor, he was mailed that date. His original dates were October 12th, October 19th, October 26th, November 9th, and November 16th. He did not appear October 19th. He was a kind of a no-call, no-show for that day on the work program. He did not report to the probation department within 5 days after. I'm not sure if you're aware, I was actually out of town for those 2 weeks. So in normal circumstances, Mr. Hickerson would have been removed from the work program on that October 26th date, but he was not removed. I was out of the office, unable to remove him. So we let him continue on his work program in an effort to make up the 19th, where he doesn't have to pay the 135, serve an extra day. We rescheduled him, and I mailed that date out to him. It's the address, it's the same address that he has told the court he has. We're not aware of any trailer. The notice he signed with his original dates has that exact address on it. If his address was incorrect, he did not notify the court or the probation.
Hand that to Ms. Wilds. Now, what is the date of the letter that was sent out in your hand?
In my hand, sent out November 13th,
And it was scheduling the court work program for the
November
20th.
23rd.
My client's completed all of the other dates as he needs to. He'll complete the other one. He'll make up for it, give me an additional one, Your Honor. He's aware of it now. He'll do it.
Anything you want to say, Mr. Hickerson?
I'm just confused at this whole situation, Your Honor,
Why are you confused?
because I don't understand how I got mailed the date, but ended up getting arrested the day or a day or two after Christmas. Told I have a warrant for my arrest for failure to appear, and then a day or two later, that piece of mail came into the house. I'm sorry, I ended up receiving that piece of mail.
Well, you failed to appear for a show cause on December 10th. That's why you had a warrant for your arrest.
I was unaware of that as well.
And that was for this show cause.
Didn't know about it.
How many days does he get? One?
He owes just the 1 day at this point in time, Your Honor.
I believe everything's paid off.
What's that?
I was just telling him that I believe everything. I always.
Why weren't you there the
but
19th of October?
The 19th of October?
Yeah.
I showed up 2 minutes late and was unaware I had to contact probation or anything. I was just figured I would go the next day. I'd receive something in the mail about it or something.
Listen. Let you schedule you. We'll just schedule you for the last day on the court work program. I'll take your plea. But I won't do anything. Let's just reschedule him for the last day on the court.
Absolutely, Judge.
And the bond will be returned, all right? So the bond will be returned to you.
Okay.
If it's in your name, I don't know. Oh, it's in Kayla Children's name, so the bond will be returned to her, okay?
Thank you, Your Honor.
Good luck. We'll reschedule you today. Don't go anywhere, okay?
Sounds good.
Thank you, Judge.
Good luck. All right, what else do we have now? Down there. I'll take it. People against Reamer. Nathan Terrell Reamer, 24M723-784.
Michael A. Carmen, P73824 on behalf of the defendant, Your Honor.
Mr. Reamer, your name?
Nathan Reamer.
You gotta take your hat off, please. All right, where are you at? Are you in Westland right now?
Yes, I am.
Okay. If you plead guilty here, the possible penalties to operating while intoxicated, right? And the super drunk to be dismissed?
Yes, sir.
All right. If you plead guilty here, the possible penalties are up to $500 fines, 93 days jail, 360 hours community service court costs are all 6 points will be added to your traffic record. Your license will be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes.
All right, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to question their witnesses. You have the right at a trial to testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge, and you still wish to plead guilty to operating while intoxicated?
There's no contest.
No, it doesn't say anything about.
I'm sorry, Your Honor. I think we marked the wrong box. I'm sorry. This should be a no contest. I'm sorry. We marked the wrong box.
Your appearance,
And I didn't.
I'm sorry.
your appearance.
Mohammed on behalf of the people.
Your Honor, I'm asking that we do it as a no contact under lack of memory. There was an accident in this case and it impaired Mr. Reamer's ability to actually, he doesn't remember what happened.
Judge, I didn't sign off on a no contest, so we're gonna have to go back.
Wait a minute, slow down. Was there an accident?
Yes,
Was anybody else hurt?
No.
Your Honor, not that I'm aware of.
I'm talking to your lawyer. Just hang on, Mr.
I'm
Reamer,
sorry.
please. Can somebody enlighten me as to what the blood or breath test result was?
BAC was 0.31.
All right, well, I mean, if he's got a 3-1, it is possible that he has a lack of memory. If you guys want to do a no contest, I have no objection to it at all. I will just need the police report. So in the future, if you're going to do a no contest, and I'm
We'll
not saying,
stipulate to the police report for a factual
Thank-
basis.
all right. But I'm just saying in the future, if you're going to bring these in, like if you were agreeing to a no contest, just make sure I have the police report handy, okay?
I think it's in there, Your Honor.
So I know, just on top, so we don't have to purge through all of this. All right, let me just double check. All right, so this is gonna be a no contest plea then, right, Mr. Mohammed?
If there's a stipulation to the police report, then yeah.
Well, I'm always gonna require that. I need a factual basis somehow. If we're gonna do a no contest, I just want you to change that stipulated plea agreement to reflect that. I have no issue with it. Sounds like there definitely could be a lack of memory. And based on the extent to which the blood or breath result was at that level. So, sir, if you plead no contest, I want you to understand that it has the same effect as a guilty plea. Do you understand that?
Yes.
I'm just not going to ask you any questions. I'm going to rely on the police report to establish that you're guilty. Do you understand that?
Yes.
So if you plead no contest, possible penalties are up to $500 in fines, 93 days jail, costs are all those, 2 points. I'm sorry, 6 points. Your license will be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes.
All right. Do you have any questions?
No, I do not.
All right. To the charge of operating while intoxicated, how do you plead?
No contest.
All right, and again, you stipulate I can use the police report to establish a factual basis?
Yes, sir, Your Honor.
All right, I'm going to review the report. Based on my review of the report, I find there's a factual basis for the plea. Are you on probation or parole, sir?
No, I'm not.
Anybody force you to plead no contest or promise you anything to induce you to plead no contest?
No.
And you're doing so freely and voluntarily?
Yes.
Plea is accepted to that charge. Find it to be an accurate plea, and I'm talking to the charge of operating while intoxicated. The super drunk charge is dismissed. I'm going to refer you for a screening and assessment. You'll be screened and assessed today, sentenced at a later time. Lisa, do we still need a court to school sentencing for the Brownstown Middle School.
We do, but it's my understanding that he cannot travel or leave to a medical issue.
Is that true?
Yeah, sure. My client is in a wheelchair as a result of the accident. Is that accurate, Mr. Reamer?
Yes.
Can I ask you a question? You're coming from Westland, is that right?
Yes, sir.
I don't want to inconvenience you too much. And if you tell me, Judge, I just can't, that's one thing. I'd really appreciate it if you can make it to consider doing this in front of the junior high over there. It would be a really good thing for them. And I don't mean that at your expense or anything else. I'm sorry you got hurt. If you can't, you can't. If you tell me, Judge, it's just really too difficult, whatever the case, I get it. I'm not going to try to talk you into it. If you
Yeah.
can do it, I'd appreciate. What's that?
Oh, no, it's agreeing with you. I see. Yeah, it is kind of just too hard to due to transportation and everything.
All right, good enough. We're going to order a screening and assessment. You're going to stay on now, and probation's going to come on and interview you. And we're going to give you another sentence date, and Lisa, that will be on,
January 28th at 8:30.
okay, the 28th at 8:30, all right?
Okay.
Is it okay with Zoom?
Yeah, I'm okay with Zoom, but I want you going to AANA at least 3 times a week. I did not set this bond, but it's no contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. I want you going to AANA at least 3 times a week. I'll let you go by Zoom,
Okay.
but you have to provide a paragraph or so about what was discussed, where it was, what date, the Zoom number, etc. And you're to take all prescribed medicines as prescribed and take all precautionary measures. Screening and assessment, sentence date will be the 28th. You can Zoom in from there, but I want you to start going every 3 times a week, okay?
Okay.
All right, good luck to you. I wish you a speedy recovery.
Thank you. So now, how would I go about doing the AA meetings through Zoom?
You
How
can
do
do
I
it on Zoom. You speak to the probation officer when they come in and they'll handle it, all right?
Okay, thank you so
They'll
much.
explain everything to you. Thank you.
Thank you.
Be safe, be well, sleep sweet, and much love.